The future of progressive radio. This is the Dean Obadala Show on Sirius XM Progress 127.
And welcome back, Dean Obadala Show. We're live right here in studio with our friend Danny Cevallos, MSNBC legal analyst. You can watch it on Facebook.com/Dean of Radio if you want to see Danny and I fight each other and watch the video and not just hear the words. Danny, ring the bell. Fight Club. No, I'm kidding. It's not that extreme.
Oh, we don't have a bell? I was waiting for a bell.
Ding, ding, ding. No fight. All right, Danny, couple of things. This is apparently sentencing memo week. This is really big. On the second day of Christmas, my true love gave me a sentencing memo. So before we talk about right now, everywhere, breaking news, we're waiting release of Michael Flynn's sentencing memo. Explain to people what the hell is a sentencing memo.
In the federal and state systems, when you are convicted of a crime, the court sets, especially in federal court, they'll set a sentencing date several months out. And if you're a cooperating witness, it could be even more than that because you have to cooperate with the government to their satisfaction. So often is the case, the government will continue that hearing for months at a time so that you can continue to cooperate. Now, once sentencing is ready to go forward, the defendant and the prosecution will each submit sentencing memoranda, and that is basically each side's final argument to the judge why, given the facts, given the conviction, given the facts that both sides agree or don't agree upon, that the defense should get the least amount of years or the least amount of punishment, and the prosecution is often arguing for the most punishment. But I have to say, in the case of a cooperating witness, they occupy kind of an odd space because the defense's challenge is to ask for the least amount of punishment possible, but still stay within the strictures of their plea agreement or the cooperation agreement. And then the government has agreed, in all likelihood, to tell the judge what a good cooperating witness you've been, but at the same time, they have to ask for a reasonable sentence. So in a way, it becomes even more challenging, at least for me, when preparing sentencing memoranda for a cooperating witness.
How much do these actually influence a judge?
That's the great question. I mean,
who knows?
That's why
they paid me medium bucks.
They pay. Yeah, I wonder how much judges really consider sentencing memoranda. I've read a number of law review articles by judges that indicate that they do consider them.
Really?
One of the things I don't think they consider very much is the defendant's allocution. I think by the time the sentencing date has arrived, they both received the judges have detailed sentencing memoranda from both sides, and they've made up their mind. I just don't believe they're making up snap decisions right there at the bar of the court.
Allocution, what is that for people again?
So every defendant has the absolute constitutional right to speak to the judge who's about to sentence him or her. And in most cases, this is not a great idea, but certainly a defendant has the absolute right, the constitutional right to allocute, to speak to the judge and give his pitch why he should be given the least sentence possible. The problem is most defendants, for a lack of a better way to put it, Dean, they're just not that great at talking in court.
They are defendants. They've been convicted of a crime, so right there.
That's right. That's right.
Something about that.
And it also creates concerns if there's an appealable issue. But I mean, generally speaking, it can be a real risk to have a defendant speak at his allocution.
Was there ever one that you can remember, either your client or someone you were watching, that was so horribly bad you had to fight laughing?
I have seen, Dean, I would never dare laugh. I might laugh at some other poor attorney's client. But, you see it all the time that a defendant, no matter how much you prepare a client for what the sentencing is and what it is not, some defendants can't help but see it as their opportunity to set the record straight with the judge. In many cases, it's the only time they're ever going to be able to speak to the judge. The problem there is that if they don't understand the purpose of a sentencing hearing or a plea hearing and what's being done, or even if they do understand and they think they still if they just had an opportunity to explain everything to the judge would throw the case out. A lot of times you can see both plea deals go bad and you can see sentencing hearings go south when a defendant speaks in court and gets himself into more trouble than he was to begin with. That's
not good at all.
No, it's not good at all. No.
So before we give a lot of weight, because we're going to get a sentencing memo from first Robert Mueller gives his sentencing report for Michael Flynn. Then Michael Flynn's attorneys will have an opportunity to write their own, or the same deadline?
Michael Flynn's attorneys, ordinarily, they would submit them first, and then the government submits theirs.
Okay.
But it really doesn't make that much of a difference who submits first, because you can pretty much predict what each side is going to do. There really aren't many surprises in a sentencing memorandum. There's creative advocacy. There's well-written. I have to say, I read Michael Flynn's team's sentencing memorandum earlier last week, and it was quite good. I think they did a very good job. Here are the things that you do. And the interesting thing is we focus so much on trials.
Right.
But the sentencing phase, the penalty phase of a trial, is often every bit as important. And I'll give you an example. In a slam dunk case where a defendant almost has to plead guilty because there's a smoking gun and he's certainly going to be convicted, or if he goes to trial and he is convicted, deciding how much time he gets is half the battle. I mean, sure, it's great to win a case, but there's a lot of range in those sentencing guidelines. So a real huge battle is sentencing and presenting to the court. And the good news for defendants is that virtually anything is admissible at sentencing to persuade a court that you should be given the least possible sentence.
So let me ask you in the big picture, because we're going to get 3 sentencing memos this week. When a defense attorney submits we're going to get them from Mueller, but when a defense attorney submits a sentencing memo, in general, everything in there has to be truthful, I assume, right? I mean, like, they're making an argument, but they can't say. They're saying it based on what their client said. So, if, for example, we're talking about Michael Cohen.
Yes.
Right, so we're talking about Michael Cohen's sentencing memo in a second.
Right.
So if Michael Cohen said, I did this because Donald Trump directed me to, if his lawyers didn't believe that, they wouldn't put that in the sentencing memo?
Yes, but that's the kind of thing you want to stay away from. You don't want to get into disputed. You can dispute facts. You can say, for example, that a common thing that's disputed is whether or not a defendant was a leader or organizer of a criminal enterprise, which has a very significant effect on your sentence in federal court. Mm-hmm. And a lot of times the attorneys will argue about whether the facts constitute a defendant who was a leader or organizer, or was he just a mule? Was he just a courier? Right. Was he just carrying things? And so
I view myself as a mule.
Yes, exactly. And so for that reason, you'll have attorneys arguing, and you'll have the government be at a different place in terms of how they interpret the facts. But I mean, defense attorneys aren't going to go out on a limb too far and simply adopt a view of their client, because that can be obviously very risky. The thing to do in a sentencing memorandum is talk about comparable cases, talk about, and I know we're all looking for something spicy in sentencing memoranda this week, but it may not be as exciting as you thought, because, I mean, for example, the only thing the Michael Cohen thing was a shock.
Don't ruin it. We're going to get to that one in a second.
Okay, all right, good. All right, I don't want to ruin it because I do have some thoughts on that.
Let's talk to a lawyer who's never been disbarred. Here is Mike from
Wait a minute. Oh, Mike from San Diego.
I'm not saying you're disbarred yet, so I'm just saying, and I haven't either. I'm on the disabled list, though. You know that I'm actually technically retired in New Jersey and New York as a lawyer.
Well, you put in a long career, Dean.
I did.
I mean, it's exhausting.
5 to 6 grueling years of law.
It's exhausting.
Folks, the reason I'm on the retired list, just so it's clear, is that in New York and New Jersey, I imagine most jurisdictions, as a lawyer, you have to pay annual fees or every other year and do continuing legal education. So if you don't go on the DL there, and I don't mean the down law, I mean the disabled list, you actually have to keep paying these fees, and you have to keep going for continuing legal education. So I'm a lawyer, but I'm retired. But I can come out of retirement anytime I want, but I have to pay a bunch of fees and take some courses.
That's right. It's a lot of that continuing education. I'm admitted in 5 different jurisdictions, and those continuing education requirements and the fees, substantial part of the firm's budget goes towards all these renewal fees and licenses and everything else.
The firm paid it in your case?
Well, yeah, it's my firm. Yeah.
Oh, it's your firm.
Why not?
Well, all right. Let's have Mike, who does criminal defense attorney law all the time, is his bread and butter. Mike, how are you, my friend?
Hey guys, how's it going?
Mike says this is his bread and butter. So
it's my bread and butter.
So
yes,
Mike,
any federal practitioner, as Mike is an experienced federal practitioner, is a master of sentencing.
So Mike, how important? This week we're going to get 3 sentencing memos from Mueller. One with Cohen. One, if everything is accurate here, one with Cohen, one with Flynn, and one with Paul Manafort for his new lying. How important are these documents?
Well, they're very important, but I think the real heart and soul of what the government knows is going to be under seal. I can't
Oh,
imagine
really?
That's right. I agree.
They would put it.
Why
they
didn't you
would
tell
put
me
it in
that,
a
Danny?
sentencing memorandum.
I'm kidding.
And,
Right.
and just defense too. I think the defense would want it under seal as well, for the judge's eyes and ears only. And that's the way to go, I think, to protect both the people of the United States and the
Right, because right now, the Michael Flynn sentencing memo from Mueller, whatever Flynn gave them, they're not going to reveal all of that in that document because they have an ongoing investigation.
Exactly. Yeah,
Right.
they're not going to compromise an investigation. That's why, frankly, that's why sentencing is often pushed off, because if you have a cooperating witness, that's exactly the kind of thing you don't want to bring to the
So
attention
why are
of
they
an open
doing it
court.
now? Why aren't they waiting
Why aren't they waiting?
for Michael Flynn? Why is this happening?
His
Why is
cooperation apparently
done.
is finished, has come to a close. Otherwise, if they thought they would tip off any other possible targets or subjects or anything else, then they wouldn't be sentencing him. Is that right, Michael?
I think that's true, and I think in Manafort's case, I think they're ticked off. I think they're burning with what he did and what his lawyer did, and they want to get him in front of a judge ASAP.
So let me ask you about, while we've got you here, Mike, because you do a lot of criminal defense work. That's your bread and butter, as you say.
That's all I do.
And I'd love to have, and Danny, both of you, but have two people, because I was trying to make the point last week, what Paul Manafort did, being a double agent for Trump, essentially, it's not something I have ever heard of or read about before, but perhaps I'm not informed. So Danny and Mike, we'll start with you, Danny. You're here. How out of the ordinary and shocking was that development, that Paul Manafort was playing both against each other?
Yeah, first of all, why does Mike get to call in and I have to come down here? This is outrageous.
He's only on for a few more minutes, and we pay you nothing. So we give you free water.
It's ridiculous. I do take advantage of the free coffee and tea. Now, all right. So what the significance of that was, it was a pretty big deal to me, because generally when you have similarly or commonly aligned defendants, there's a thing called a common interest agreement or a joint defense agreement that they can enter into, and that allows them to share information among them. The problem is, once a defendant cooperates, you can't possibly make a straight-faced argument that that defendant still has a common interest with the other defendants or potential defendants. So the fact that Paul Manafort may have been communicating information back and forth through a barrier that was not protected by attorney-client privilege is really, really concerning. I mean, it's the kind of thing I don't think any attorneys want to get themselves involved in. So, I mean, the facts as I see them right now, they seem to be very concerning. If it's true that Paul Manafort was acting as a go-between or an informant while he was
against the U.S. government for
right.
Donald Trump, the head of the U.S. government.
That's right.
Unreal. And Mike, what about you? How shocking, out of the normal? Have you ever heard of this before?
Dino, 40 years as a trial lawyer, I have never seen that or even heard that before. I got to believe that Manafort's lawyer is sweating bullets. I don't think he ever thought that Giuliani would out him about the source of their information.
Downing? Kevin Downing?
The investigation. They're gonna file obstruction of justice against that attorney.
That's what I was going to ask you. You guys think they're going to charge the lawyer?
I hope not, Michael, because here's why I say I hope not, because how often do clients burn their attorneys? I mean, his lawyers may not have known anything about this. I don't know.
The reporting is that the lawyer was the one that went and told Giuliani what was up. I mean, that's what I saw in the reporting, I thought.
If he's sitting there during these debriefs and he knows Manafort is lying through his teeth, and he doesn't do anything to try to change it or curtail it or tell him to tell the truth, he's in deep.
But Mike, this is exactly the point that I think you and I are making the same point in a way. A lot of times you sit in those debriefing, and the primary source of your knowledge is not only what your client has told you he knows, but possibly what your client has lied to you about what he doesn't know. And whenever you have a cooperating witness, there's an incredible premium on not knowing things. Think about it. As long as the government thinks you're cooperating, the less you know, the better. So these clients, they walk in and they try to play, games, and the defense attorney may be the last person in the room to know about it, because the U.S. attorneys know and the client knows. Maybe the attorney doesn't.
I give him the benefit of the doubt, I guess, but I'm skeptical. I don't think so. You're an experienced attorney, trial attorney. You've been in I don't know how many debriefs. You've been talking to clients. You get a sense, hey, you're giving me BS, fella. You can't go in there and tell this to the government. They know the answers to most of the questions anyway. You got to tell the truth.
That's
and
right.
If you don't do that, or you don't try to do that, you're asking for trouble. I think he's in trouble. I really do.
Interesting. Well, we'll see how this plays. We're going to find out this weekend, perhaps. I mean, by Friday, perhaps, with the Manafort. But they don't have to charge the lawyer. It's just going to be about Manafort. But what they say in that sentencing memo from Mueller could be very interesting. But all right. So, Mike, thank you, my friend, for calling in. I appreciate it. It's always nice to chat with you.
You're welcome.
All right.
You're welcome, guys. Take care.
Take
Bye-bye.
care. So, Danny, when we come back, I want to talk a little bit about the Flynn sentencing memo submitted by his lawyers and what jumped out at me. And I'd love to get your response. And excuse me?
Cohen,
I'm sorry. Yes.
Yeah.
Cohen's. And what jumped out at me in your experience as a long time doing criminal defense law for now 60 or 70 years, how significant or not it is. Be right back with more of the Dean Obeidallah Show right after this. You're listening to the Dean Obeidallah Show, where we crush Trump's lies every single day.
On Sirius XM Progress 127. The biggest stories of the day. Right now. This is the Dean Obeidallah Show.
On Sirius XM Progress 127.
And welcome back, Danny Cevallos Show. I'm Dean Obeidallah, his guest here.
Welcome.
It's a matter of time that Danny takes over the show, folks. That's what he's angling for. Danny, Michael Cohen sentencing memo. A few things I wanted to ask you about. One is it said beginning, and this is the sentencing memo from Michael Cohen's lawyers, folks, that he submitted to the judge to get his client no jail time was the goal. It says, beginning before the entry of his plea on August 21st, 2018, that was the first guilty plea of Michael Cohen. Continuing through November, Michael participated in 7 voluntary interviews with the special counsel's office of the DOJ. And then we learned he had 70 hours of conversation with special counsel. On the spectrum of this is normal to, like, I can't believe how many hours and how much time they spent with him. Where does this fall?
70 hours is a lot. I mean, you spend a lot of time debriefing, but 70 hours is significant. And two things emerged from Michael Cohen's sentencing memorandum for me. One was that he is what you call, this is a study in contrast between Michael Cohen as the prosecutor's dream when it comes to cooperation, and you see defendants like this, and then on the other hand, Paul Manafort, who is both a defense attorney's and a prosecutor's nightmare when it comes to cooperators. Paul Manafort represents all the risks that can happen when the government decides to cooperate. Now, practically, most cooperators end up cooperating, but that doesn't mean that they don't have to be encouraged or warned about the fibs that they're telling before they get back onto the path to cooperation. So you have Manafort on one end. Michael Cohen, what jumps out is that this is a guy that as soon as the government was at his door, he was the picture of cooperation. He volunteered things. He volunteered, whether or not he took a sip of sacramental wine when he was an altar boy, or that's the kind of defendant that they want. And that's so in that sense, when he spoke to the AG, he met with all the U.S. attorneys. He's going to max out on his what we call a 5K1, his reduction in sentence, which can be the most significant reducing factor in a sentence. The interesting thing is that with Michael Cohen, the crime that he pleaded guilty to last week had a pretty low sentencing guideline range to begin with, which last week had me feeling that there's so much that is still the tip of the iceberg here. But one thing that really jumped out at me, really shocked me about Michael Cohen's sentencing memorandum was this. Up until the day he walked in and pleaded guilty last week, I think most of us believe that the reason he pleaded guilty in the summer without a plea or a cooperation agreement was because the special counsel maybe didn't believe him, or that he didn't demonstrate that he had enough value. It appears from his sentencing memorandum that instead, if this is to be believed, according to his attorneys, he didn't even want to wait for all the time it would take to cooperate, all the continuances or the adjournments of his sentencing. He wanted to get in, plead guilty, and then basically promise, pinky swear, that he would continue to cooperate with prosecutors. And it's a deal that prosecutors probably didn't mind taking at all. After all, they plead him guilty, they get their conviction, and then he's going to promise to cooperate. And the prosecutors hold all the cards. He's got to come dazzle them with what he knows. And apparently he did it successfully, because now they're willing to deal with him.
There's a lot of different facts, I should say, between Michael Cohen's case and Paul Manafort. Does one of them, is it fair to think one of them is the fact that Michael Cohen is 52, Paul Manafort is 69, and what Manafort's already been convicted of, 8 counts already, and plead guilty to 2 others, that in all likelihood, Paul Manafort's going away for the rest of his life, or most of his natural life, no matter what. So maybe he goes the Hail Mary with trying to get a pardon from Trump.
That's
while
right.
Cohen is a younger middle-aged guy, 52.
Family.
He's got a family. He doesn't want to spend the rest of his life in prison and be a much longer time. Maybe he gets out in 5 years, 3 years, who knows? That's part of the incentive here.
What you just described is the thought process that almost every white-collar defendant goes through when they're approached by the government. And that's why so many of them end up pleading guilty, because maybe they have families, they have kids who rely on them. And from the minute the government shows up at their door, the only thought they have is, what can I do to get through this with the least amount of time possible? Or ideally, is there a possibility, given my crimes, that I could serve no time in prison? That's what a lot of white-collar criminals really want above all. And whatever that path is, they're willing to do it. Michael Cohen appears to be one of these people who has said, I will do anything to get the lowest possible sentence. And his is a case, and I haven't looked at the guidelines recently, but it's not outside the range of possibility. It would be a below guideline sentence in all probability. And again, it's been a while since I looked, Mike from San Diego, but at least for this crime, the simple pleading the perjury to Congress, that one has 0 to 6 months. I mean, even without cooperation, he could get a time served. So the sentencing memorandum that was filed didn't ask for make an unreasonable request. This is a guy who was already in the 0 to 6 month range, cooperated, and which means he's entitled to a reduction on that sentence where he already has a possible range of 0. So in the world of federal sentencing, which is often very harsh and can land you in prison for a very long time, a 0 to 6 sentencing guideline is it's the lowest range in the federal sentencing guidelines. So it's a dream come true.
When Michael Cohen pled guilty and was cooperating, the Trump team, of course, said Michael Cohen's a liar. He's a big liar. And Trump himself said he's a liar. You've tried countless cases, dealt with many cases where a cooperating witness is a liar. Cooperating witness is actually a criminal who's pled guilty to crimes. And they get on the stand and you'll cross-examine and go, haven't you made a deal with the prosecutor? And you go through all their crimes. How effective is that if it actually got to a trial in destroying the credibility of the liar working with the government versus the potential liar who's on trial?
I couldn't give you a percentage ratio, but generally speaking, what I find is that jurors are willing to accept that the person who comes into court and points their finger at the defendant at the defense table is not an angel. It's not somebody who's a cherub. Jurors seem to get that it takes a criminal to catch a criminal. So even though a defense attorney, and I'm not saying that sometimes some cooperating witnesses are flat out liars and they're doing whatever they can to get a better sentence. But many's the time that I thought, well, geez, no one could possibly believe this guy after, all the character flaws he has. But sometimes jurors realize that look, if the defendant's a criminal, he probably hung out with criminals, and one of his buddies is pointing him out, and sure, he got a deal, but jurors can live with that. Still, that I don't want to take away from the fact that a cooperating witness, deciding to cooperate a witness, is a huge risk for the government, because every single cooperating witness comes with a risk. It comes with baggage, so that they know from the gate that they're going to give a defense attorney plenty of fodder in a case to stand up and say, look, the government is hand in hand with a convicted liar, with a criminal. These are the kind of people that you're gonna believe? I think not. So yes, it can be effective. If the government balances its entire case on the head of a slimy cooperating witness, then they are running some real risks. On the other hand, what I think you're going to see in the Michael Cohen situation is that Michael Cohen, even if a defense attorney somewhere down the line stands up and points out what a liar he is, no matter what, he's probably provided documents and other witnesses and corroborating evidence so that the government can stand up at the end of trial and say, look, Michael Cohen has flaws. Michael Cohen is a criminal. Yeah, we understand that. But look at all the documents that he provided. People lie. Things don't lie.
Oh, you must have heard that argument.
Oh,
sounds like that argument.
I'm just an amalgam of different arguments that I've stolen from other smarter attorneys than me.
So what do you think about Rudy Giuliani's attacking? They did it before. Now they started to ramp it up again. That somehow the Trump team, the Mueller team's like the Gestapo. I mean, we're one step from them calling them Nazis. They're calling them everything out there. And then Judge Napolitano, who I keep quoting on my show now, I'm playing clips because I respect from before, as I told you, he was a judge and I appeared before him in Jersey, that he said Rudy did the same thing to browbeat or to persuade or to compel people to flip and work with the government when he was U.S. attorney. Is that fair to say? Have you found U.S. attorneys to be, I'm not going to say unethical, but certainly very pressure-oriented? Is that how do you put it?
Well, I think there's a huge difference between zealous advocacy and unethical. I mean, that is the line. There's an entire body of rules of ethics that we lawyers have to learn so that we know where the line is between zealous advocacy and violating the rules of ethics. And I think what you find, especially with federal prosecutors, is that they're incredibly bright, they're incredibly pedigreed, they're talented. I mean, they really are the Olympians of attorneys in many ways, in their training and their education. So they're ambitious folks, and for prosecutors that to advance, it generally helps to have a pretty good record of prosecuting. At the same time, you're not going to get very far if you bring ticky-tack cases that your superiors don't care about. But yeah, on the whole, federal prosecutors are generally very honest folks to deal with.
Right.
I'm sure Mike in San Diego is snapping his pencil in half, but I think, look, I've had prosecutors that I get frustrated with. I get angry at them. I curse them under my breath. breath. I cursed them out loud. Obviously not to their face, but and they've made me very, very frustrated. But on the whole, I think that on the whole, federal prosecutors and prosecutors in general are not bad folks.
So we were waiting for the Michael Flynn memo. It just came out. Literally just came out. Right when we're here, they're going to call Danny right away.
Wow.
So we're going to print it out. We're going to, well, it just came out, so maybe Danny can find it. Well, according to what we're seeing online, and we're going to take a break in a minute and look at it in the commercial break and come back and give you the first take on it. Well, Danny Cevallos' first take, as if I'm paying him like at MSNBC to talk about this stuff. But what we're seeing here, Flynn is given, in quotes, substantial assistance, and they're asking for no prison time.
Yeah.
It has no priors. It was one lie, I guess, to the FBI, and he worked with them to get no prison time. What does that mean to you that they're recommending no prison time?
I think, and I need to look at the sentencing memo, but I believe his range was the same as Cohen's that we were talking about. I think he's in the 0 to 6 months. He's a criminal history category of 1, and I think his offense level is
so
1
no,
as well.
We can't do chance of lock him up. We could
that's not true. I mean, remember, the judge is not bound by what the government.
That's a great point. That's a great point. Could they actually? If the state says, the prosecution says no jail time, a judge goes, "Sorry, I'm giving him jail time."
Right. Well, that happens exceedingly rarely. If anything, you generally see the prosecutor wanting a lot more or some sentence, especially in federal court. So it's theoretically possible, but it's not going to happen. And politically speaking, no judge would want to wade into the politics in a case like this by giving a sentence that neither party wanted. If both parties are on board with a non-custodial sentence, then it would be insane to me for a judge to take matters into his own hands and then and sentence him to more.
All right. So before we take a break, because we're going to come back and talk about this, I wanted to ask you this question: were you surprised when Donald Trump tweeted calling for Michael Cohen, a man who he hired in 2007 to be his legal counsel and executive vice president, that Michael Cohen, asking for no prison time, did terrible things? I'm paraphrasing the tweet, but this is essentially, he should go and serve a full and complete sentence. How stunning was that for Donald Trump to tweet, to call for the man who used to be his consigliere, his buddy, to get a full and complete sentence in prison?
That Donald Trump would turn on someone from his past doesn't surprise me that much on Twitter. I mean, only because he's done it before, and I think that's one of his leadership techniques, is to keep everybody wondering where exactly they stand with him. So that doesn't really surprise me that much. I think betrayal is just part of doing business, and it's worked to his advantage in some situations, and now maybe it won't work to his advantage. But yeah, I was surprised. I mean, I grew up having read Bugliosi's book about the Manson trials, and I know those trials were almost upended because President Nixon made an offhand comment about the guilt of Charles Manson.
I remember hearing about this, right?
And you know what I found is there's not a whole lot of case law, believe it or not, on when the president makes an offhand comment about the guilt or innocence of somebody. So you really can't find a lot of situations where that's come up in litigation or in actual criminal cases. But to me, the executive is the branch that does the prosecution. And so for the president to be weighing in like this is Mystery Science Theater, it's not just some random person opining on the justice system. It's the head of the justice system. And even more than that, the executive branch is the only branch that has one person as its head. The others, you can get rid of a few folks and the system moves on just fine. But if there is a king in our system, it's of the executive branch, and it's the president.
I love you call it Mystery Science Theater, as I know Frank Conniff, who used to do that all the time. All right, let's take a quick break. We're going to come back. We're going to do our best to read a little bit of this sentencing memo that Mueller literally just released about Michael Flynn, who was, as a reminder, Donald Trump's national security advisor, who lied to the FBI about his conversations during the transition with the Russians, about that you discussed sanctions and lifting sanctions. He said no to the FBI. That was a lie. And of course, as we probably all remember, Donald Trump asked James Comey to let Michael Flynn go on this. He's a good guy and all of that, which might end up being part of the obstruction of justice charges against Trump. Ultimately, we'll see. Let's take a quick break. Come right back more with Danny Cevallos. You're not going to want to miss it. Danny Cevallos, usually on TV, giving the breakdown. He's going to give it right here, the Dean Obeidallah Show, after this break. progressive values are the best of American values, and we need to keep fighting for them to save our country.
Don't go anywhere. This is the Dean Obadala Show on Sirius XM Progress 127. New perspectives, important voices, influential ideas. This is the Dean Obadala Show on Sirius XM Progress 127.
And welcome back to the Dean Obadala Show. We're looking at the heavily redacted Michael Flynn sentencing memo that Matt got us through his contacts in the DOJ, or actually online. But in any event, we got him, and
Wait, I don't
have the redacted parts.
I don't have a redacted
Something's
portion.
missing. They have something
What
different.
date was this?
They have a different. They have a memo. They have a different memo. We have here. We have the memo, but there's something else they have that's redacted. Maybe we have the non. Matt got us a non-redacted part.
Matt,
Oh my God, we got
Matt works for
classified
the Mueller
confidential
team.
information here. That, yeah, that's what Matt does during the day. He works for Robert Mueller, and this is direct from the Mueller team. Well, it just goes through. Danny, anything jump out? It says the defendant deserves credit for accepting responsibility in a timely fashion. I'm looking at page 5, and substantially assisting the government. Oh, the addendum. We don't have that. As described in the addendum, shortly after special counsel reached out to the defendant to seek his cooperation, the defendant accepted responsibility for his unlawful conduct and began cooperating with the government. So this is really short. That's the only thing it says here about him. There's an addendum that has other stuff that's heavily redacted. They actually say nice things about him here. He served in the military for 33 years.
Yeah, they definitely. The government is on board with him getting a non-incarceration sentence or non-custodial sentence, and it's an interesting thing. I mean, having a non-incarceration sentence in federal court is a pretty rare thing on the whole, And he pleaded guilty to a single count of, one count of false statements. That's
Right.
1001. Same category that Michael Cohen pleaded guilty to. Slightly different. I don't know. I don't think it's the same exact subsection. But the point is this. At a criminal, like I said, offense levels 4, criminal history categories 1. So what happens is he has what's called an advisory guideline range, like I said, of 0 to 6 months. That is the lowest range of federal sentencing guidelines. So no matter how much he cooperated, he's still going to be in that range of 0 to 6 months. So the government doesn't lose any face by saying, you know what? If he gets a non-custodial sentence, we're okay with that.
It's interesting, though. We were all expecting, and we're going to see more in the addendum, but that is heavily redacted, and Matt's getting that right now. They're showing pages on TV. But it's interesting to me that when you look at this, it reminds me of some of the story of what went on. So this first series of false statements occurred during an interview with the FBI on January 24th, 2017. And what's interesting to me is it was just a few days before that Trump calls Comey out for dinner out of the blue. He says, let's have dinner, and then asks for his loyalty. He didn't bring up Michael Flynn until February. And I wonder if this was scheduled days before, even on January 20th, let's say, and Flynn goes to Trump and goes, the FBI wants to talk to me. And Trump goes, let me take care of it. I'll go talk to the FBI and ask Comey for his loyalty. And he goes, I'll give you his loyalty of truth, I think absolute truth or something like that's what he said.
Honest loyalty.
Honest loyalty. I also find interesting that there's no dispute about this because I covered this many times. The day George Papadopoulos got a surprise visit from the FBI, January 20, 2017, in the morning, that afternoon is when Donald Trump calls James Comey out of the blue and says, let's have dinner together. And when you look at the timeline of Mueller, he had answered that question for me finally, because I knew it was the same day that they went to Papadopoulos in the morning when he was taking a shower, getting ready to go to work or go out. They interviewed him for a few hours, and then he's back home. And then Donald Trump calls up James Comey. So for me, that connects it all. All right, we have one more break. All right, so let's take one more break. We're going to come back and read the addendum a little bit, and we're going to update you on what we're seeing here. I think we were all hoping for something bigger than what's going to be in here, like something where everyone was waiting in the media for something to say, like, this is what Flynn told us. He told us, Flynn, that Trump talked to the Russians and blah, 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 and that was never going to happen.
No, I said that the Manafort filing is going to be far more interesting. I said it emphatically last week, and I stand by that because sentencing memoranda don't normally have anything that sexy in them. They're really just after all the facts are known. It'd be strange to start introducing a bunch of new facts and exhibits into a sentencing memorandum after you've already essentially conceded your guilt.
So let's take a quick break. We're going to come back and talk about, we got the addendum here, which is heavily redacted. So thank you, Matt. We'll be right back with more of the Dean Obeidallah Show and our friend MSNBC legal analyst Danny Cevallos right after this.
Dean Obeidallah Show on Sirius XM Progress 127. Dean Obadala Show on Sirius XM Progress 127.
And welcome back to Legal Talk with Dean Obadala and Danny Cevallos, our new show, and that's what we're calling it. So we just went through, so right now, folks, right before we went to the break, we told you the Robert Mueller sentencing memo for Michael Flynn, Donald Trump's former national security advisor, a man who lied to the FBI, was released. We'd gotten part of it. Now we got, during the break, thanks to Matt, the addendum giving us much more details, sort of more details. Danny, what is your takeaway when you look at this more specific document that details a little bit more information?
The sentencing memorandum itself is pretty ho-hum, and that's normally the case because it's really just a math formula when you're figuring out in the Matrix what, and not the Matrix, the movie, the Matrix of sentencing guidelines, what the defendant, what his range should be. And then once you figure that out, generally it's a bunch of what a great guy he is. But the addendum is really compelling, not for what it says, but for what is redacted from the addendum. And just going on the simple logical conclusion that you don't redact a bunch of stuff, as you know, obviously our listeners can't see it, but there is a lot of redacted information in here. So you don't typically see that unless there's a lot of stuff that the government feels would either compromise an investigation or, and I don't think that's the case here, but sometimes it's the actual cooperator themselves that has to be, I've worried often not so much about the government's investigation. I've worried more for my client's safety. So definitely there's always that possibility that they're redacting things for that reason. But I think there's a lot of significant information and a lot of prolonged cooperation in this case, which demonstrates that Michael Flynn had value. And interestingly enough, again, there may be a tip of the iceberg situation here, which is, given that Michael Flynn was charged with Section 1001, he arguably could have pleaded guilty and still had a sentencing guideline range. Well, you know what? I take that back because I think the government must have had other things they could have charged him with.
That's what I heard too.
Yeah, that's right. I'm backtracking on that one.
But here, I just want to, in page 1 of the addendum to the sentencing memo, it talks about Michael Flynn's work with the government is more than just with Russia, too. So it says the defendant assisted with several ongoing investigations. Now, several, that's more than 2 in general, several.
Yes.
So it's saying 2, several. And it says specifically a criminal investigation and then a black line redacted. So there's some criminal investigation. We have no idea. Then second, it says the special counsel office investigation concerning any links or coordination between the Russian government and individuals associated with the campaign of Donald J. Trump, comma, and then a big black line again. So there are 2 other criminal investigations. We have no idea. And for those like me who's hoping Flynn helped incriminate Trump, they might be giving him a benefit because he helped with some other criminal investigations unconnected to Donald Trump, because there are 2 other, and I'm just being fair here. I don't want people to go either way. I'm just trying to be fair about what we're seeing here. But the fact Donald J. Trump's name is in this, we all know pisses off Trump because we heard that last week. So I'm glad Trump is pissed off. I think it's so interesting when they go, one of my favorite things here on page 2, it says, the defendant has provided substantial assistance in a criminal investigation, and then a page and a half of black lines.
Yeah.
So there is some case out there, and we're holding it up to light. We're doing everything we can to figure out what that is. You can't see it. I wonder, we have no idea. It could be, could it not be completely unrelated to the Trump world? I'm just trying to go the spectrum of what this could be.
I want to say that could be going on. It could be. Remember, Robert Mueller's mandate is to investigate Russian interference with the United States election. And I think people need to be prepared for the fact that Mueller's mandate is not go get Trump. Mueller can complete his duties and not ever have even touched Trump. So it's possible that this may be about more Russians. It could be about something in Turkey. Right. It could be about a lot of different things. And those other investigations might not relate to the president.
And Mueller already has indicted 12 or 13 GRU members of the Russian military. It could be that. It could be. And then the other side of the spectrum, the criminal investigation could, don't get too excited, could involve Donald Trump Jr. in meeting at Trump Tower. It could involve the Jared Kushner wanting to have a back channel. People might remember this. There's so much going on with his family. Back channel way at the embassy to communicate with the Russians. Who knows? So the spectrum is vast here. But one specific thing is that the defendant, this is in the words of Robert Mueller's team, the defendant has assisted with several ongoing investigations, and one of them very clearly is the Special Counsel's Office investigation concerning any links or coordination between the Russian government and individuals associated with the campaign of Trump. And then it goes on to talk about the transition team and that there was, Danny, as you pointed out something there about several senior members of the transition team publicly repeated false information conveyed to them by the defendant about communication between him and the Russian ambassador regarding the sanctions, and then a whole bunch of blank lines there. And, and there's also something here with my people. The Palestinians are involved in this too here. Not in a way that they're any implicated. It says, after the election, the defendant communicated with the Russian ambassador to the U.S. as a representative of the transition team on two sensitive matters: a UN Security Council vote on a resolution calling for Israel to cease settlement activities in Palestinian territory, and the Obama administration's imposition of sanctions and other measures on Russia for interfering in the election.
Yeah. And keep in mind, again, before people start thinking that it's all going to cave in on President Trump,
right?
Michael Flynn pleaded guilty to lying to the investigation. In other words, it's a crime that didn't exist until the Mueller team knocked on his door. They may have had other things they could have charged him with, and they may still, although I don't think that part is possible, or is likely, I should say. But a lot of these crimes, these Section 1001 false statements, are crimes that only existed by virtue of the investigation. They flowed because these people tried to lie to investigators.
We only have a minute left. And to remind people, by the way, that when Michael Flynn committed these crimes, there was no Robert Mueller yet. Robert Mueller was not appointed until May of 2017. This is sort of the precursor that led, I think, in the way where Rod Rosenstein goes, we need a special counsel. Danny, we got 30 seconds left. What would you like to finish?
Well, as you can see, I brought an entire volume of the United States Code. If you don't mind, I'd like to read starting at Section 1 up to Section 10,000.
It's going to take forever. Okay, folks, thank you for tuning in.
Next
Tomorrow,
time.
I'm sure we're going to cover more of this Michael Flynn stuff and what this all means. Thanks for tuning in. Have a great night. Look forward to chatting with you tomorrow. Thanks, Danny, for coming in. Lauren and Matt, you've done a great job. And Matt McDonough, wherever he is. I want to thank Matt McDonough. Be right back tomorrow night.